Today on Subrogation, we're going to discuss pre-suit license suspensions, also called administrative license suspensions. I'm your host, Kim Rathbone. Now, pre-suit license suspensions are a great tool for subrogation professionals to use in order to recover on uninsured subrogation claims. This is where the BMV is notified that a party failed to show proof of insurance at a traffic incident that occurred. The purpose of this is to protect the public by discouraging people who are driving without insurance and really encouraging people to buy insurance in the first place. Not all states allow this. For example, Connecticut does not, but generally it's pretty easy. A letter to the BMV notifying of the non-compliance of having insurance will generally suffice. However, there are some states that are more protective of their constituents and make their procedures more rigorous in order for a license to be suspended. Here's some details that you should pay attention to when completing an administrative license suspension. There are some states that require forms or particular documents to be attached. For example, Ohio has a BMV 3303 form that has to be sent to the BMV when notifying of noncompliance. Now, there are other states where they will only suspend for an incident that was within their state. Louisiana is an example of that. If the accident occurred in Texas, when you notify the Louisiana resident that caused the Texas accident, the state of Louisiana will not suspend their license under that incident as a result because it's not in that state. There are other states that allow only certain parties to have their license suspended. For example, Nebraska will only allow a driver to have their license suspended, not an owner, while most states will permit both the owner and the driver to be suspended. Another requirement is, with many states, is that it either has to involve personal injury, a death, or some minimum amount of property damage. For example, Wisconsin requires a minimum of $1,000 in property damage in order for a license to be suspended. So you want to be careful about the balance of your claim when you're pursuing a property-only administrative license suspension. There are also states that have different time limitations for the BMV to be notified. For example, Ohio again has a 6-month time limit in order to submit that 3303 form. If it's submitted outside of the 6 months, they will not suspend the license of the person who is driving without insurance. And just bear in mind that for varying states, they have different lengths of time where the suspension is valid. For example, Delaware, it's only valid for about 6 months. Louisiana for a year. Another requirement for some states is that it be the insured who notifies the BMV instead of the insurer as the agent for the BMV. So there are certain states where if you're the insurance company or the professional that's working for the insurance company or on behalf of the insurance company, then you cannot avail yourself of this. It has to be the insured that notifies the BMV that someone was driving without insurance. Georgia's an example of that. There are other states where only the police can notify the BMV and not the insurer. An example of that is Colorado. And there are other states that really go to the nth degree to protect the constituents and make sure that they were truly driving without insurance before their license is suspended. An example of that is Nevada, where they require a hearing and a determination for the likelihood of liability to be assessed to that person before suspending that license administratively. So we have some procedural recommendations for you when attempting to suspend a license pre-suit. If you can just do it through a letter to the BMV and not a form, we would recommend that you use general language just advising that the tortfeasor appeared to be driving without insurance. There's really not a need to provide direction to suspend the license. The BMV has very particular procedures that they're going to follow once you notify them that someone appeared to be driving without insurance. And really this is to protect the party that's sending in the letter in the first place. It's not the insurer that suspended the license, it's the BMV that suspended the license. And so the BMV is who the tortfeasor will need to deal with, even if it's in conjunction with the subrogating carrier. Also, when notifying the BMV, send a copy of the letter to the tort at the same time. That will prompt them to respond directly to the carrier or the subrogate professional quicker and hopefully resolve the case. And bear in mind, some states have particular notice mailing requirements, and make sure to follow those. Now, when a payment arrangement is reached, extremely promptly notify the BMV of that payment arrangement. Some of them allow you to email or fax the letter. I would also recommend sending a copy of that letter to the tortfeasor, again by either email or fax. When you speak to the tortfeasor, encourage the tortfeasor to take a copy to the BMV. Now, part of the reason for this is that you also want to remind them that the BMV is going to have their own requirements in order to reinstate a license. It's not just that the payment arrangements needed to be made with the carrier in order to get the license back in many states. There are many states that require proof of insurance. There are others that require an additional fine to be paid. And there's even some that require an additional driver's test to be passed before that person can receive their license back in valid order. Now, there's really only one shot at a pre-suit administrative license suspension once it's already suspended. Resuspension is not generally permitted until you get into litigation and obtain a judgment. So be sure to get the arrangement that you're looking for in order to release the license pre-suit. Thanks for joining us on subrogation. That's the long and short of it.